The Supreme Court today has put the controversial sedition law in abeyance till the government reviews it. In simple terms, it means the law and its application has been put on hold until further notice. This order by the apex court impacts hundreds of Indians. At least 13,000 are supposed to be or believed to be in jail under the provisions of sedition. So very often called the anti-national law as well, has been used by various government states and centers in the past as well to hit out at people who dissent or disagree with them. What is the significance of what we've seen today? Abhishek Manu Singhvi, senior advocate and Rajya Sabha member of parliament, on the show with me. Mr. Singhvi, thank you so much for speaking with us this evening on Beyond the Headline. Let me come to the first point of what is the impact of what the Supreme Court has said today. Has effectively this law been stayed for the cases which are under trial, for the appeals which are under trial? And does it effectively not allow state and centre to file fresh cases? What does it really mean?
The answer to each of your questions is yes. It means a temporary interim status quo regarding all cases, including filing of fresh cases. Now, that's the short answer. The longer and the more nuanced answer is that it's a very desirable, very welcome judgment. It's something which should be fully supported. You must remember that never in the history of 75 years of Indian independence has been either the quantity of Sedition 124A misuse been as its present levels from 2015 till now, nor in terms of the nature and the qualitative category of cases. The comedian, the stand-up comedian, the satirist, the writer, the free speech pusher in journalism, the Mewanis from Gujarat to Assam, many, many, many. There have been other large number of non-Congress governments. There have been earlier BJP governments. But never before has there been this degree of misuse. And two simple statistics make that clear. Roughly 763 arrests in the last 6-7 years, and hardly 12 convictions or 11 convictions. Now, the point is that they know when they charge you that you are going to get ultimately bail or be released, etc., etc. They know that the case they're filing is frivolous, very superficial. The threshold is very low. But they equally know that the process of you getting bail, the process of you getting your freedom, will be minimum 6 weeks, 8 weeks, 12 weeks. That is sufficient harassment. All these redressals through courts are ex post facto. They are curative. They are not preventive. So I would like the Supreme Court, when it deals with it in detail, to add at least one guideline which injects an element of preventiveness in the whole process. Police officers should be made aware that if they invoke this casually, as they have been doing in the last 7 years, they additionally would be liable to be penalized, whether in their service record or otherwise. This alone will put the fear, the hesitancy to invoke this provision. I also think the Supreme Court did a remarkable job, because 3 times they fixed the date for hearing of this case. And 3 times the government begged, borrowed, and kind of managed an adjournment. This time, the government came with a more bizarre adjournment by another name. They said, look, okay, we've sought it 3 times, so we won't seek an adjournment. What we're telling you, my lords, is that your lordships will allow us to consider, we are of the same view, we will initiate legislative redressal. Now, that's the vaguest general statement. Doesn't tell you when, where, how much time, after 2 years, after 4 years. And it was another adjournment tactic by another name. The court turned it on its head and said, look, if that is so, you're agreeing, we will give you that time, but in the meanwhile, the sedition law will be stayed.
Sir, so just on the point that you made, the government has said that we will come back with a revised version. So do we now have the fear, or can we have a situation where the law doesn't completely go away, but comes back in another form, maybe watered down, some guidelines, some of the things that have been suggested today, like let a superintendent of police have, final say on whether that case should be filed. So is the law, the sedition law, actually gone for good, or is it now waiting in the wings to make a comeback, maybe in a watered down way?
2 or 3 quick points. One, it is absolutely misleading to suggest that because I have challenged law X today and the court is hearing the validity and challenge to that, you come along and say, look, we are thinking of changing the law in the future. If you do, you can change it. But that does not affect the court's jurisdiction to decide the matter in present time. And that's what the court has done, at least by an interim order. If you change the law after 1 year, 6 months, 2 years, God knows when, well, that could be a separate challenge. Or it may need no challenge. But that's a separate matter. So it's very misleading to say that, look, please don't hear the matter because I'm thinking of changing the law. That itself is fallacious. Second, there are two ways. One is the law deserves to be struck down. I am normally not in favor of absolute, one-sidedness. But the way this law has been misused in 7 years odd, the quantum and the qualitative misuse, the humongous misuse, leads one to think whether repeal alone or rather striking down alone would not be the best way. Alternatively, of course, the ideal way would be to make a very detailed set of guidelines. And the devil and God both lie in details. They should cover all aspects. They should tell you how, when not to initiate, the very rarest of rare tests by which you can initiate, and inbuilt penalties if you wrongly initiate. Now, that is the alternative. Normally, I would go for this, but given the track record for the last 6-7 years, there is a view which is coming around very fast that this will not brook anything except a striking down.
So, I would like you to put on your hat as lawmaker as well, and taking ahead the point that you made that governments, state, centre, political parties love to use sedition. It's the favorite and favoured stick to beat down dissenters with. We've seen the way it's been used across states and across party lines, I would go as far as to say. Do you think there is any merit in the argument that you need some parts of the law to protect against spreading disaffection against the state, to protect against treason, to protect the interests of national security? Is there any merit to those arguments? Is there any space for any version of sedition?
First and foremost, let us be clear. Anything seriously impinging on the sovereignty, the integrity, the security of India, you have tons of laws more than adequate to deal with it. Anti-terrorism laws, UAPA, several other laws, Criminal Procedure Code, IPC, etc., etc. It is not that this is a law which is going to be a major gap if it doesn't exist. Secondly, I do understand that for that very typical paradigm case, I standing on the roundabout and maybe, using explosives or exhorting the populace to rise up in rebellion against the established authority of the state, against the Prime Minister, against the President of India, against Parliament, or against all indicia of Indian sovereignty. That kind of case would alone, in that narrow category, justify the existing sedition law, which is why the Kedarnath court in the 60s in the Supreme Court put it in that narrow category. But the problem is, it is not used like that. It is not invoked like that. Let me be clear. While different states of different political color in India have misused it, and I condemn all, irrespective of political color, let me tell you that Einstein's law, to every action there is an equal and opposite reaction, is what is happening. The ruling party, BJP, has misused it to such an extent that there are now reactive aberrations. But I have no hesitation in saying that the primary misuse has been by this ruling party in the last 7 years. And today, I think it is important to put that in perspective. It's not that two wrongs make a right. It's not that other states' misuse is being condoned, but the quantity, the quality, the sheer ruthlessness of invocation by this government and its various state government manifestations has been absolutely despicable and horrible.
So, last question here, and I think this is the one about relevance. The argument has been that the misuse of sedition has had a chilling effect on free speech. Does that change from today? Effectively, for citizens, can they now speak their mind, or do they still have the fear of other laws being used to clamp down?
It is not that we are a lawless world. It is not that India should be lawless. Nobody is advocating that. There is a law of defamation. There is the Unlawful Prevention Act. There is various other anti-terrorism laws. As I said, if you stand up and start defaming right, left, and center, there is the IT Act which controls social media posting. So don't think that anybody is calling for a lawless society. The question is that today, put your hand on your heart as a journalist, put your hand on your heart as a comedian, put your hand on your heart as a raconteur, as a satirist, as a writer. Are you not looking over your shoulder in the last several years? Are you not expecting around the corner some silly sedition case, somebody filing in faraway state?
So that's my question. Does that change after that? Does that change after today with sedition being stayed?
100% it does. 100% it does. It gives you a confidence. It gives you an immunity. It gives you a protection. And it makes you feel more secure. After all, if you have a 19(1)(a) right, that right can't be reduced to vanishing point. 19(1)(a) free speech right is already conditioned. It is not absolute. Today, already the Constitution says you cannot exercise free speech at the cost of defamation. You can't exercise free speech at the cost of the country's sovereignty, foreign relations, etc. But sedition is not the answer. It's a colonial law, A. B, it is highly vaguely worded. C, you are not following Kedarnath in almost 95% cases. D, you are having absolutely subjective interpretations that anybody who kind of criticizes you, you simply threaten them, overawe them, scare them by the misuse of this law. And therefore, I have no doubt that this judgment will have a very salutary, somewhat belatedly necessary, positive, reinforcing confidence effect.
Right. Well, it's a historical day indeed. This colonial law has finally been put into abeyance, has been stayed. Let's hope it doesn't return in another version. Thank you so much, Dr. Singhvi, for speaking with us today.